Alex Jones tried to avoid the law, but it looks like the law caught up. And in the process, he's finally going to lose his shirt. Unintentionally this time. Yes, it looks like Alex Jones is going to be forced to sell off his personal fortune to pay off his debts. But it's not all good news. Unfortunately, it looks like he'll be able to keep hiding his corporate assets from plaintiffs.
I didn't believe we were this and we are this.
But Jones's most disturbing obsession has been denying the deaths of the 26 people murdered at the Sandy Hook Elementary School. For years, Jones and his associates have insisted the whole thing was a hoax and that the 21st graders did not really die that day, and in the process, he encouraged his viewers to harass the surviving family members. Jones's fans responded by stalking the families, both online and in person, and the families finally filed suit against Jones and won judgments totaling almost $1.5 billion in Connecticut and Texas. But so far, Jones hasn't paid anything on those judgments, instead funneling millions of dollars from Infowars to himself and his relatives, at least on paper, all while claiming to be broke. Again, on paper. And he filed for bankruptcy, again on paper, before the Connecticut trial was over and eventually produced a suspicious invoice making it look like Infowars owed his parents $54 million. And as a result, the bankruptcy proceedings have largely stalled the collections process for 2 years. However, things are finally looking up for the plaintiffs. Yes, the federal bankruptcy court in Texas held a hearing on June 14th to determine whether to dismiss the bankruptcy proceeding, which would be super bad news for Alex Jones, or convert it to a Chapter 7 liquidation, which would be even worse. Both of these options would allow plaintiffs to seize some of Jones's property at long last. And now that he's being forced to sell his property, Jones told his viewers that he's doing it all for the children.
It's been a hard fight. These people hate our children.
So today we're going to talk about how we're getting to the end of the bankruptcy of Alex Jones and how it's super bad news for Alex Jones. Now, we've covered what happened at Sandy Hook Elementary many times. And a quick recap. On December 14th, 2012, a gunman murdered 20 first graders and 6 teachers at Sandy Hook Elementary School. Jones spent the next decade promoting lies about the massacre, suggesting that the government staged the shooting, that grieving parents were crisis actors, and that the incident was manufactured so that Obama could take away all of our precious guns. Jones used this Infowars program to promote people like Jim Fetzer, a retired professor who wrote a book called Nobody Died at Sandy Hook. Fetzer spread malicious lies like the death certificates for shooting victims had been faked and that a shooting victim's gravestone was actually a computer-generated graphic. He accused Sandy Hook parent Leonard Posner of being, quote, a different man named Reuben Wagner, who he insists is part of some international Jewish conspiracy. He claimed the children were actually crisis actors, and he claimed a whole bunch of other crazy nonsense. Now, Infowars chief editor Paul Watson told Jones, quote, it makes us look really bad to align with people who harass parents of dead kids, but Jones was only too happy to align with people who harass the parents of dead kids because it helped him sell massive quantities of nutritional supplements. And so Jones made at least 20 more videos with false claims about Sandy Hook. But Jones didn't just lie to his audience, he encouraged them to investigate the situation on their own, and a court concluded that Jones intended to activate his audience. Millions of people watched and listened to Infowars, and some of them stalked and targeted the Sandy Hook families and first responders. Now, eventually the Sandy Hook families had had enough harassment from Jones and his associates, so they filed defamation lawsuits against Jones, Infowars, and related companies in Connecticut and Texas. Now, despite all the evidence that 26 people lost their lives that day, Jones broadcasted lies about Sandy Hook for over 5 years, and during a deposition in that case, Jones finally admitted what everyone else already knew, that the gunman murdered 26 people. Jones said that he had a form of psychosis that led him to believe it was all a hoax. Now, the Connecticut case went to trial, but only on damages because Jones refused to obey the court's discovery orders and failed to meaningfully participate in the discovery process. So after Jones basically refused to give any information about himself and his companies, the judge entered a default judgment on liability as a sanction, and the jury awarded the plaintiffs $965 million. The court ordered Jones to pay an additional $473 million in punitive damages. Jones tried the same tactic in the Texas case and was met with a similar result. And after a default judgment, the jury awarded the victims $49 million. Jones and his company, Free Speech Systems, now owe the Sandy Hook plaintiffs nearly $1.5 billion in damages. And so far, they have yet to see a penny of that money because Jones has claimed to be broke and filed for bankruptcy. Now, Jones first filed for personal bankruptcy, but since Infowars is also liable, its parent company, Free Speech Systems, also filed for bankruptcy under Chapter 11. Now, Chapter 11 bankruptcy is the nice bankruptcy. It allows a person or company to reorganize, lower its debts, and continue as a going concern. Now, in 2019, Congress passed the Small Business Reorganization Act to make it easier for small businesses without a lot of assets to go through the bankruptcy process faster and with less oversight. This is known as Subchapter 5 of Chapter 11. Now, initially, Subchapter 5 was only available to companies whose debts were under $2.7 million. But once COVID hit, Congress raised the threshold to $7.5 million. Now, Jones thought he could outsmart the plaintiffs by putting Free Speech Systems in the Subchapter 5 bankruptcy proceedings before the Connecticut jury assessed damages. And according to the bankruptcy filings, Free Speech Systems reported $79 million in liabilities. But wait a minute, how did Free Speech Systems qualify as a small business if it had $79 million in debt? Didn't I just say that a company needs to have less than $7.5 million in eligible debt? Well, Subchapter 5 contains a sneaky exception for insider and affiliated debt. Section 1182 of the Bankruptcy Code states that for Subchapter 5 eligibility, the term debtor means a person engaged in commercial or business activities, including any affiliate of such person that is also a debtor under this title, and excluding a person whose primary activity is the business of owning single asset real estate, that has aggregate non-contingent liquidated secured and unsecured debts as of the date of the filing of the petition or the date of the order for relief in an amount not more than $7,500,000, excluding debts owed to one or more affiliates or insiders, not less than 50% of which arose from the commercial or business activities of the debtor. This means that if the debtor owes a debt to a company or person affiliated with the debtor, the debts don't count against the $7.5 million. So if Free Speech Systems owed money to one of Jones's other companies or to Jones himself, those debts don't count when calculating whether Free Speech Systems can elect Subchapter 5 treatment. And according to Jones's lawyers, his companies were exactly like the small family business that were intended to be beneficiaries of Subchapter 5. Except that Free Speech Systems owes $53 million to a company called PQPR Holdings. And guess who owns PQPR Holdings? Well, it's Alex Jones himself and his parents, David and Carol Jones. And PQPR Holdings is the company that supplies Infowars with the supplements that he makes so much money on, nearly $500,000 a week. And if this all smells fishy to you, well, yeah, it's basically a giant rotted fish. Because Jones engineered all this, the debt, the bankruptcy, and the suspicious supplement sales, all in order to stop the plaintiffs from ever collecting on the damages award. And we know that this is what Jones intended because he said so. While the Sandy Hook verdict was being read, Jones urged his followers to pretty please buy the supplements. So Jones thought he was smarter than everybody else, and it sure looked weird that a company that made as much money as Infowars somehow owed nearly $55 million to a supplement company. But Jones had figured that out too. In the words of Liz Dye, by sheer coincidence, PQPR forgot to build the company for a period of years, only remembering the debt when Jones's refusal to cooperate with discovery netted him default judgments in multiple states. Not that you needed more evidence, but David Jones is a dentist and Carol Jones is a homemaker. I guess they just forgot to invoice their son's company for about $54 million in supplements. See, Infowars is a classic mom and pop operation. Now, the plaintiffs rightfully called BS on the entire scheme. As I pointed out, once Jones knew he was about to be on the receiving end of a massive judgment, he started transferring money out of Free Speech Systems. Quote, after the defamation cases began, the Jones debtors started transferring large sums of money to the Jones transferees. These sums included money that the Jones debtors started regularly transferring from Free Speech Systems to PQPR the same month that the default judgments were rendered. In fact, the month the default judgments were rendered, Free Speech Systems started transferring to PQPR between $11,000 per day and $11,000 per week, plus 60 to 80% of Free Speech Systems sales revenue, supposedly just to pay the interest on the alleged $54 million debt. Free Speech Systems claims these payments are part of the financial disentanglement between the two companies. In reality, their transfer is designed to siphon off the Jones debtors' assets to make them judgment-proof. You probably already knew this, but a fraudulent transfer is an effort to avoid debt by transferring assets to another person or company that are not bona fide. And the Subchapter 5 trustee assigned to the case investigated for 10 months and then filed a report concluding that, quote, based on the lack of corporate formalities, commingling of assets, and general course of dealings between PQPR and FSS, including Dr. Jones's clear involvement in directing which of FSS's creditors were paid, the trustee does not believe that the asserted secured PQPR debt is legitimate. The trustee also found that, quote, it is difficult to view FSS and PQPR as anything but one entity, and it's difficult to accept that the establishment of the two promissory notes with PQPR were merely coincidental. And so far, the bankruptcy court has yet to rule on the trustee's report. Meanwhile, Free Speech Systems is still grinding through the bankruptcy process. The parties were supposed to collaborate on a reorganization plan, but Jones stymied that by proposing that the first creditor in line would be PQPR Holdings, meaning that the mom-and-pop supplement shop would get paid before any of the parents of the dead children. And Jones is following the same pattern he established in the defamation cases, stall by making ridiculous arguments while the plaintiffs followed the rules. But notwithstanding, the plaintiffs kept their eyes on the prize. Their ultimate goal has been to dislodge the bankruptcy filing so they can begin the collections process against Jones and his related companies. And right now, they can't do anything without the approval of the two bankruptcy trustees. So the plaintiffs filed a motion arguing that the defendant's debt should be non-dischargeable in bankruptcy. Now, we've talked about this before. Non-dischargeable debt is a type of debt that cannot be eliminated through the bankruptcy proceeding. Most student loans are not dischargeable in bankruptcy, and same with alimony and child support, as well as state and federal taxes. And the Bankruptcy Code 11 U.S.C. 523 lists all of the types of non-dischargeable debts, including those which are, quote, willful and malicious injury by the debtor to another entity or to the property of another entity. Now, that section exists to punish debtors who commit egregious and intentional acts. And the plaintiffs have argued that Jones has engaged in all kinds of fraudulent transfers and that he shouldn't be rewarded for his moral turpitude. Now, the bankruptcy judge concluded that the judgments were fully and fairly litigated, despite Jones's many complaints about not being allowed to put on a defense. And the bankruptcy court decided that most of Jones's acts that gave rise to the defamation and other claims were made with the requisite mental state. Judge Christopher Lopez said that the Connecticut State Court had clearly determined that Jones's conduct was willful and malicious, and this finding was, quote, also necessary to the judgment and the jury award of damages. Judge Lopez said, quote, these are specific findings about an objective certainty of harm and a subjective motive to cause harm in connection with the defamation and intentional infliction of emotional distress claims. They are not, as Jones argues, superfluous findings about intent related to the plaintiff's harm. It is irrelevant that the state court could have awarded damages on reckless acts. What is important is what the court actually did. Here there are findings about a deliberate and intentional act meant to cause injury, not just a deliberate act that leads to injury. The state court also considered the additional factors listed above, but the focus remained on willful and intentional acts and not on a lesser standard like recklessness. In sum, the state court made specific findings that went directly to the amount of punitive damages. They were necessary to the judgment. So summary judgment is granted on the debt for CU-TPA punitive damages. Judge Lopez ruled that almost all the damages were non-dischargeable in bankruptcy. $1.15 billion of the damages owed to the Connecticut plaintiffs and $4.3 million of the damages owed to the Texas plaintiffs. Now that was a big win for the plaintiffs, but that was all the way back in October of 2023. At the moment, the case is still sitting in bankruptcy court and the plaintiffs still can't begin state court proceedings to collect on the judgments. Meanwhile, Jones has been having meltdowns on his show, calling on his viewers to join hands and form a circle of human shields around his Austin studio.
I just want to fucking stop these people. They gotta be stopped. We gotta stop them.
Now, obviously, if you're Alex Jones, you need a good bankruptcy lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. You can click the link below. But in May of 2024, plaintiffs filed an emergency motion to convert Free Speech Systems' bankruptcy petition to a Chapter 7 bankruptcy. Now, Chapter 7 bankruptcy is the mean one, where you just liquidate all the assets and cash it all out. The plaintiffs argued, quote, FSS has now lingered in bankruptcy for almost 2 years. At this time, FSS has no prospect of a confirmable plan of reorganization and has failed to demonstrate any hope of beginning to satisfy the Connecticut family's claims. As the court has made clear, it is time for the FSS case to come to a conclusion. The relevant question at this juncture is how it should come to a conclusion. So the plaintiffs proposed converting the bankruptcy petition to a Chapter 7 liquidation. As they argued, quote, a Chapter 7 conversion would allow a trustee to pursue approximately $4 million in potential preference claims that have already been identified by the debtor. The Connecticut families firmly believe the interests of the estate and all creditors would be best served by conversion as opposed to a dismissal of the FSS case in light of the unique circumstances. Jones's public statements over the past 44 hours, which expressed his belief that this court will, quote, wash his hands like Pontius Pilate of the case and thereby enable Jones to regain control of FSS and frustrate creditor claims, even if it requires physically blockading FSS's offices, only reinforce a significant need for conversion. The families point out that while this case has been stalled in bankruptcy court, Free Speech Systems is hemorrhaging money. Quote, total cash on hand and receivables have decreased by over 50% since the petition date, all while FSS has incurred nearly $2.3 million in professional fees since the commencement of the FSS case. FSS's failure to effectuate substantial consummation of a confirmed plan constitutes independent grounds for cause to convert the case. 2 years have passed and FSS has failed to propose any viable plan of reorganization, much less one with creditor support. So what does this mean? Well, if the petition is converted to a liquidation under Chapter 7, it would pave the way for Infowars to be sold. Free Speech Systems reportedly had about $4 million in cash on hand at the end of April, with $1.9 million in expenses. And since Free Speech Systems owns Infowars, it would be sold. Judge Lopez ruled that Free Speech Systems can continue to pay its 44 employees their wages and other expenses until the June 14th hearing. And Jones's lawyers said it's possible that Free Speech Systems would withdraw the bankruptcy petition. The court could also just dismiss the bankruptcy case entirely, and in both of those circumstances, the plaintiffs would then be free to start the collection process in state court. Though at the same time, the plaintiffs might actually prefer to have the petition converted to a liquidation simply to ensure that the court retains jurisdiction in the bankruptcy court to rule on that bogus debt attributable to PQPR Holdings. And then there's still the matter of Jones's personal bankruptcy. At the end of May, Jones told his fans that, quote, "This is going to be Infowars' last show because I learned yesterday that they were going to padlock the door and kick us out last night." Jones said that the feds were wandering around his 127-acre game ranch, and the court gave Jones the green light to sell that ranch. But of course, Jones didn't actually stop broadcasting. He returned on June 1st with claims that the government had padlocked the ranch, but then reversed course after an audit, which is, quote, "totally blowing up in their faces right now." But all this is, of course, just grift theater. The show is still broadcasting, and Jones asked the bankruptcy court for permission to liquidate his personal assets. Many of Jones's personal possessions and some real estate would be included in the sale, with the proceeds probably going to the Sandy Hook plaintiffs. And it looks like Jones currently has about $9 million in personal assets. And of course, the plaintiffs know they'll never see anything close to the $1 billion from Jones. They offered to settle for $85 million, but Jones would only go as high as $55 million doled out over 10 years. And after the latest hearing, the bankruptcy court agreed to liquidate Jones's personal assets. But what about the fate of Free Speech Systems? Well, one day before the hearing, Subchapter 5 trustee Melissa Haselden filed a scathing status report announcing that the parties could not find a consensual resolution that would have allowed for a Chapter 11 plan. As a result, she recommended converting all of the proceedings to a Chapter 7 liquidation. Haselden expressed her concern that Jones' quote, "increasingly poisonous rhetoric, including slipping back into post-petition unsubstantiated theories related to the Sandy Hook shootings, creates potential additional financial harm to the estate." Notably, Haselden found that Jones is still promoting Sandy Hook conspiracy theories. Quote, "Since June 7, 2024, Jones initiated repeated on-air attacks of the Sandy Hook plaintiffs, including promoting new conspiracy theories, continued denigration of the bankruptcy process and publication of the CRO's photo, and a recording of a telephone call with the CRO, questioning who has authority over the company and that he, Jones, is in charge in all regards, and urged viewers to sponsor and support his father's product since Infowars is dead." Basically, Jones is promoting his father's company, quote, "because his father knew Infowars would be shut down and urges viewers to support his embattled family by purchasing from drjonesnaturals.com and that drjonesnaturals.com has emergency stuff backed up." And Jones made it clear that he was doing this as an end run around the bankruptcy proceedings, saying, quote, "Wherever we go in the future, whatever happens, that's my dad's company, and he's going to be a sponsor for the future." And although Jones mentions his Infowars store, he, quote, "always alludes to the fact that Jones believes Infowars may be shut down and not deliver products to his customer, which he later walks back and tells customers it may be their last chance." The trustee claims that Jones is also trying to get rid of years' worth of videos on the Infowars site. This is problematic because, quote, "this content is owned by the debtor and is property of the FSS estate. The trustee believes that some or all of this content is available to the public for free download. However, SSS content should not be used for any commercial purpose by any person other than the debtor. The value of any FSS property should inure to the benefit of the debtors, creditors, or Jones' impending Chapter 7 estate." The trustee is focused first and foremost on employee safety and security. The trustee is also very concerned about the preservation of assets of the estate and payment of administrative obligations incurred during the bankruptcy, including professional compensation, but more importantly, all tax, employee, and costs of business operation. The trustee is concerned about both the behavior of Jones as well as the potential behavior of some of his viewers. Jones's behavior in the recent broadcast is much more erratic and unhinged than his typical rhetoric. Haselden said the court must address questions of authority because, as of right now, employees don't know who they answer to, Jones or the trustees. Without these issues being addressed, quote, "FSS Security will not know whether to take direction from Alex Jones or the court-appointed responsible person." So because of all that, the trustee recommended a Chapter 7 conversion. Quote, "The trustee believes that there is inventory that can be sold, which would likely yield greater value if sold in a wind-down as opposed to a non-operating debtor. There's also potential value in the Infowars platform. There's a potential for value loss if the debtor does not operate in an orderly wind-down. A conversion would permit the potential value of avoidance actions to be retained." But the court rejected the trustee's recommendation, opting instead to dismiss the bankruptcy petition. So Infowars will not be sold and Jones can stay at the helm of Free Speech Systems. He can continue to appear on air and spew the same rhetoric that led to this case in the first place. And although the plaintiffs can start collection proceedings in Connecticut and Texas, they are divided about that particular outcome. The Texas plaintiffs are pleased with the results, while the Connecticut families preferred to see Infowars shut down, even if they received less money. At the hearing, the Connecticut plaintiffs, the U.S. bankruptcy trustee, and the Subchapter 5 trustee advocated for Chapter 7 for all the reasons discussed in the trustee's report. Alex Jones has acted in total bad faith before, and after the verdicts against him, the debt to PQPR is fraudulent. He's shoveling cash out of his business to family and friends, and he's going to keep spewing his conspiracy theories about the plaintiffs. They also preferred to keep the court-appointed restructuring officer at the helm of Free Speech Systems rather than see Jones retain control of Infowars. So if Judge Lopez agreed to convert the case to Chapter 7, then the bankruptcy court would retain jurisdiction over the case and over supervision. But the plaintiffs had different incentives. The Texas plaintiffs are Scarlett Lewis and Neil Heslin, parents of 6-year-old Jesse, who was killed at Sandy Hook. Heslin and Lewis did not join their Connecticut counterparts because the Texas plaintiffs stood to gain more financially if the case was dismissed. And here's why. Heslin and Lewis got their judgment first, but it was much smaller than what the Connecticut Sandy Hook plaintiffs got. It was $4.1 million in compensatory damages and $45.2 million in punitive damages. And there's a good chance that the Texas Supreme Court will eventually reduce the amount of the jury verdict because Texas law on punitive damages only allows plaintiffs to collect up to twice what was awarded in economic compensatory damages, in addition to the amount awarded in non-economic compensatory damages, which is limited to $750,000. The upshot of this is that if the appeals court reduces the punitive damage award, the parents could wind up collecting only about $4.8 million of that $50 million verdict. And if the case was stayed in bankruptcy court, then the 20 Connecticut plaintiffs would have been entitled to a much bigger pro rata share because they were awarded $1.5 billion. If there is no bankruptcy, then all the plaintiffs can just start the collections process, and they don't have to wait to see each dollar distributed according to who is owed the largest share. And if there is no bankruptcy, then Free Speech Systems is not in liquidation, meaning that the plaintiffs can just go right ahead to state court with no waiting. So the Texas plaintiffs were willing to take their chances with Jones back at the helm of Free Speech Systems, and that's ultimately what Judge Lopez decided to do. He felt it was in the best interest of all creditors to allow plaintiffs to go through the state courts. The bankruptcy court can only babysit a company for so long. If Free Speech Systems was in Chapter 7 liquidation, then there would also be a lot of fees to the various trustees, accountants, lawyers, and other professionals who were brought in to oversee the liquidation, and that shrinks the pool of available funds even smaller. So, in essence, Jones succeeded in pitting two sets of plaintiffs against each other, and now the Texas families will try to outflank the Connecticut families in state court and probably vice versa. And what does that mean for Infowars? Well, as for the actual broadcast, probably nothing. The show is still on air, and of course, the more money Infowars makes, the better it is for plaintiffs, theoretically. Although the Connecticut and Texas plaintiffs disagree about that. The Connecticut Sandy Hook parents and their lawyers say that they'd rather have Infowars off the air. But even if Infowars went away, it's unlikely that Jones would ever shut up about Sandy Hook. And he'd still be able to start another company and produce shows saying all the same things. But right now, Free Speech Systems is in the hands of a court-appointed trustee. That's because Jones is the owner of FSS and Jones is in personal bankruptcy. His shares of FSS are up for grabs during the collections process, and Jones observed, quote, "I do not now own Infowars. It is now controlled by the court trustee. I'm the CEO and the decision maker." Now, a personal bankruptcy trustee will assume control over Jones's interest in Free Speech Systems, and the trustee's job will be to maximize the value of Jones's ownership interest in Free Speech Systems. And although that could mean forcing the company to be sold, I'm not sure that that would add a whole lot of value to the company itself because the company's value is so closely dependent on Jones's personality. Free Speech Systems has about $6 million in cash, and the plaintiffs will probably fight over that money. And as long as the company is a going concern, theoretically, it can generate more money that could eventually go to the plaintiffs. Though it does allow for the possibility that Jones will continue to play shenanigans and just siphon money out to his parents and friends. And as a result, the Connecticut plaintiffs asked Judge Lopez to issue orders directing how the trustee managed Free Speech Systems, but he indicated that he would not do so. He said, quote, "I was never asked to shut down a show today. That was never going to happen." And you can see how this would be unfair to the plaintiffs. Jones acted in bad faith in every lawsuit filed against him, and he refused to follow court orders, which is why there are two default judgments. He filed for bankruptcy before the two court verdicts, and then filed under Subchapter 5, and then invented a fake $54 million in debt. And he's diverting assets from FSS to his dad's supplement company, and after the hearing, he was preaching on the courthouse steps about how the grieving parents were part of a vast conspiracy against him. But on the other hand, it's possible some of that might be clawed back, and as a going concern, it's generating more revenue that might eventually pay off the plaintiffs. Though if I were Alex Jones's parents, I probably wouldn't do much with that money because people are going to be scrutinizing it. Now, meanwhile, the plaintiffs have filed a lawsuit in Texas alleging that Jones allegedly diverted money from FSS to other companies, and they allege that Jones withdrew at least $18 million from the company. Now, if you were going to completely revamp the Infowars show to stop lying and make logical sense, you'd probably need the power of AI. And a great place to start converting Jones's gibberish is today's sponsor, Grammarly. Now, I've been using Grammarly for ages. It's my favorite tool that makes my spelling and grammar perfect. But now Grammarly is even better because it leverages the power of generative AI to improve your writing on whatever platform you're writing on. You can tell Grammarly that you want to make your writing more exciting, more professional, or shorter, and it integrates with all the platforms that we rely on, from Google Docs to Gmail to LinkedIn to whatever. You can instantly revise your writing or even get great ideas to start writing. And Grammarly accelerates your writing process by generating and modifying text instantly on demand. As a lawyer and content creator, I have to do a lot of script writing, and Grammarly helps me translate law jargon into something more readable. And what's great is that unlike other AI tools, Grammarly tailors its output to your unique context, which is perfect for instantly creating the perfect response email. It picks up on key details and incorporates them into exactly what you're writing, and I can set my voice to be casual and empathetic, for example, if I'm writing to friends, or I can set it to be more direct if I'm writing to enemies like opposing counsel. And of course, this is Grammarly, so it helps fix poor writing in the first place, not that I would ever do that. And the free version of Grammarly is great, but Grammarly Premium has some really killer features. Grammarly lets you stay within the same program while instantly interfacing with other programs. You don't even need to copy and paste. So I can create tasks, share documents, and email folks using Grammarly so I can stay focused on what I'm actually working on. And these strategic suggestions are really slick. It makes sure that I'm never ambiguous when I write. It can remind me to set a deadline instead of leaving it unclear, or suggest that I specify the thing itself instead of relying on words like it or thing, which I unfortunately just did in the prior sentence. But you'll be amazed at what you can do with Grammarly. And Grammarly is free to use and try out, so you can sign up and download Grammarly for free with the link that's on screen right now or down below. And if you do decide to upgrade to premium, you'll get an exclusive 20% off discount. So sign up for free or get a 20% off discount for Grammarly Premium with the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.